Hello everyone, I am Rohit Rohila and I welcome all of you to today's live session on effect of non-compliance of sections 313 CrPC, which is now section 351 of BNSS. What are these provisions about? Well, these provisions grant some power to the court. Then the next question is what kind of power is granted? The courts are empowered in this provision to examine the accused. It is provided that after the evidence of the prosecution is done and before calling the accused for defense, the court is obligatory. It is obligatory on the court to examine the accused generally on the case. Now, the purpose of this examination is to give opportunity to the accused to explain the circumstances that have come against him or her. In a Supreme Court decision, you may note down Ramashankar Singh versus State of Uttar Pradesh, AIR 1962 Supreme Court 1239. 1962 Supreme Court 1239. In this case, the Supreme Court held that these provisions are not mere formality, and the examination of the accused under this provision 313 CrPC, now 351 BNSS, under this provision, it has to be conducted in such a way that principles of justice and fairness are upheld. Right? Then there are some important features related to these provisions. Number one is you must always remember that no oath is administered to the accused during such examination. Number two is the accused will not be punished for either not giving the answers or giving the wrong answers. The court, however, is free to draw the adverse inference against the accused in such a situation. Then the answers given during such examination can be considered by the court to arrive at a decision. Even the answers can be considered for some other trial or inquiry if the answers indicate that some other offenses were committed. However, we must understand that they will not be treated as evidence in the traditional understanding of the term. Why? Because there is no cross-examination of the accused. The court is simply examining, putting questions to the accused, and then clarifications are sought from him. No cross-examination is being conducted, right? This was held in the case of Sujit Biswas versus State of Assam, AIR 2013 Supreme Court 3817. 2013 Supreme Court 3817. Now we come to the effect of non-compliance. The non-compliance of this provision will only be an irregularity which will not by itself vitiate the trial. It has to be seen whether the accused was prejudiced in his defense or not. This was held in a landmark judgment of Delhi administration versus Dharampal, AIR 2001 Supreme Court 2924. A very important decision, right? You see, the non-compliance can happen in two ways. Either the examination was not conducted altogether, or the examination was conducted, but there were certain circumstances which are not put to the accused during the examination, right? Let's understand more clearly with the help of a recent decision by the Supreme Court. The case was Aizaz Ahmad Sheikh versus State of Uttar Pradesh. Aizaz Ahmad Sheikh versus State of Uttar Pradesh, 2025 LiveLaw Supreme Court 456. This case was related to a gruesome incident where the husband and the father of the victims was involved. He was the accused. The wife, along with the three daughters, they lived with the husband, but the wife was regularly put through cruel conduct. Then there used to be regular beatings. And as a result of that, one day the brother of the wife, the brother, he came and visited them to intervene, but he was asked to leave them alone. And when he was leaving, there was a request from the sister that he must not leave, he should be there, he should stay. But in the given situations, it was simply not possible. And just after few hours, when he left, just after few hours, he received the news that the his sister, and along with her three daughters, were put to fire by the accused uh, by pouring kerosene before that, right? As a result of it, one of the daughters, she died on the spot. The rest of them, including the sister, the wife of the accused, were admitted to the hospital where their dying declarations were recorded the same day, right? The trial court convicted the accused, but upon appeal to the High Court, the conviction was set aside. Now the matter was before the Supreme Court. In the appeal before the Supreme Court, the counsel for the accused pointed out that the dying declarations, the aspect of dying declarations was never put to the accused during his examination under 313 CrPC. Now, the court pointed out that this was the most unfortunate part of the prosecution evidence. Then the court clarified the law around the non-compliance of the provision by referring to another decision of the Supreme Court, which was given in Raj Kumar versus NCT of Delhi, 2023, volume 17 SCC, page 95. 2023 17 SCC 95. In this case, the Supreme Court laid down the law clearly. Number one, the court is under obligation to examine the accused upon the material circumstances that have come in the trial. Now, what are these material circumstances? These are the circumstances upon which the prosecution relies to secure a conviction. Number two, in case of non-compliance, in case of non-examination, or in cases where all the material circumstances were not put to the accused, then it has to be seen whether the prejudice has been caused to the accused or not. If no prejudice is caused, then it is simply an irregularity which can be ignored. If prejudice was caused, then again it has to be seen whether this defect is curable or non-curable. If the defect is curable, then the procedure is either the appellate court can itself examine the accused on such material circumstances which were not put during the trial, which were not put to him before, or the court can remand the case back to the trial court from the stage of recording the supplementary examination under supplementary statement under section 313 CrPC, now 351 BNSS. And in case the defect is not curable, then it is an end of everything. Nothing can be done. There is only one thing that is possible. Everything has to vanish and the person will be acquitted. Right? Then the court said that one of the factors that will weigh to decide whether the defect is curable or not It is the delay. It is the time. And this time has to be seen from the date of the incident. Now, I'll come to this date towards the end. So it will be viewed how many years, how many months have elapsed since the date of the incident, right? Now, in this case, before the Supreme Court, the prosecution heavily relied on the dying declarations, but they were never put to the accused during the examination under 313 CrPC. The court said that this has caused prejudice to the accused because fair opportunity was not given to him to explain the circumstances related to dying declaration, right? Then the court pointed out that there is a delay of 14 years. 14 years have elapsed from the date of incident. Hence, in such situation, it has become a non-curable defect, which means now the appellate court will not examine the accused on these circumstances and the case will not also be remanded back, right? The accused has to be acquitted, right? Then the court again referred to the Rajkumar's case. We have seen that already. It is referred to that case again to point out that many appeals are before the Supreme Court, where the examination under 313 CrPC is not conducted, or if conducted, not conducted properly. And this is a serious issue because till the time the appeal reaches to the Supreme Court, many years they have already passed, right? So ultimately, it will be the benefit of the accused, right? So the court has again referred to the same decision by for highlighting that the courts are empowered to frame the questions that are to be put to the accused in writing. Then those questions can be given to the prosecution. A copy can be given to the prosecution and the counsel of the accused, the defense counsel of the accused, and their assistance can be sought. And when assistance is sought from them, they are expected to behave as the officers of the court, not as the mouthpiece of their respective parties. Then this will ensure that none of the circumstances, none of the material circumstances are left out from the examination of the accused under section 313 CrPC, now 351 BNSS, right? Then courts itself in this decision, recent decision by the Supreme Court, the court itself in the third last paragraph of the judgment supplemented this by stating that when in a case of conviction, appeal is before the High Court, the first thing that the High Court must do is to see whether the proper examination of the accused was conducted or not. And in case there is an irregularity, the same can be cured at the earliest stage possible, right? Then there will not be an issue of delay when the matter ultimately reaches to the Supreme Court, right? So this was the effect of non-compliance. It is a very important provision, not only for the from the point of view of examinations, but also when you will ultimately be serving as judicial officers and even otherwise if you're a practicing lawyer, right? So that was it as far as this session is concerned, and we'll come up with more such sessions. If you do not want to miss any of them, then subscribe to the channel and like and share. Thank you. Thank you for joining today.